Morning and welcome to the General Civil and Consumer Debt Subcommittee meeting of the California Professional Program Working Group. I will begin by taking roll. Brynelson.
Here.
Fleischman.
Here.
Hamilton. Hartston. Robinson.
Here.
Shining.
Here.
And I believe Judge Yu is not joining us, at least right away this morning. We do have a quorum.
Okay, we have several attendees. Carolyn, do you want to take public comment now?
Yes.
Okay, if any attendees have public comment, please raise your hand. Doesn't look like it. So let's go ahead. We have today, if you want to advance the slide, Linda, kind of a couple things that we are hoping to do today. One is to circle back on debt collection matters and to kind of walk through with a little bit more specificity what the work entails. And we're joined by Lee Farron from the Public Law Center, who you've heard from before on that topic. And then, and also talk about creditor harassment. And we've got both Lee and then Ryan Gerber from the LA County DA's office available. I think there were questions at one point from folks wanting to hear from a DA's office on these issues. And then we hope to turn to the question of judgment enforcement work. And we will be joined to facilitate that discussion by Richard Morrison, who does this work as a non-attorney. So that's what we have on tap today. I think we'll start off with Lee, who has a hard stop, I believe, at 11. So if we could advance the slide and welcome Lee. I see you. Thank you for joining us this morning. So Lee, I kind of took your notes. I didn't include everything because you know, they were very detailed. It looks like everything doesn't actually fit on the slide, but I did send these slides out. And I asked the subcommittee if it would be helpful to have Lee kind of walk through these various steps, or do you just want to ask questions at this point? We've heard quite a bit about debt collection work. So members of the subcommittee, what would be most helpful to you at this point?
I would still like her to give us some background, walk us through.
All right, Steve?
Yeah, I would like somebody to go through each of the statutes and highlight the ones that are federal.
Okay. All right, Lee.
Okay. I will do my best to accomplish the goals that you asked. Please feel free to interrupt me if there are questions that come up. I can get on a roll sometimes. Okay, so first, I think the easiest one is identifying the federal statutes. On this particular list, the last two, the FDCPA and the TCPA, are federal. The other ones are state. So that's the easy ask.
All right.
Also,
so you said to interrupt, Lee, so I'm interrupting.
Yep, please do.
Are there additional federal statutes not listed on this slide that are relevant to this subject area?
Yeah, the Fair Credit Reporting Act, the Truth in Lending Act at times. There's a couple others that do come up with this.
Thank you.
Mm-hmm. And there's a few other state ones as well, depending on the type of debt. And that's one of the things I think that I wanted to point out, that debt collection is a really broad topic, and it can involve, you know, on this, let's see, 1, 2, 3, 4, the fifth bullet point here with what is the underlying debt, you know, it can involve any of those plus some others. And the underlying debt really does make a difference, because that can really help you understand what your potential defenses are, what if there's the likelihood of filing a cross complaint, et cetera. So I think that is particularly important. And there's reasons, and it's not always easy to initially identify. Sometimes it is. Sometimes it's very clear, what the underlying debt is, but it isn't always. The other thing I did want to point out is that hasn't really been discussed as much, is that there's all these different relevant state and federal laws, but there's also regulations and actions by state and federal agencies. So for instance, in some of our debt collection cases, we've utilized consent agreements that the Consumer Financial Protection Bureau has entered into with a credit card issuing company, because that consent agreement directly impacts our client. And we've been able to use those consent agreements to settle cases or get them dismissed. And so there are also, the CFPB is particularly one that we see a lot of. I do think that we will also start seeing more from the new California agency, the Department of Financial Protection and Innovation, which is formerly the DBO. They are being set up a little bit more like the CFPB. And so I anticipate that they'll be looking, and they actually already are looking closely at debt collection. The law is changing. They'll be licensing debt collectors in California. So there's kind of a lot of areas of state agency regulation that you'll see in this area as well. Go ahead.
Lee, could you just, before you continue, could you give us a little bit of your background and where you're from?
Oh, I'm sorry. Yes, of course. So my official title is the Director of Litigation and Pro Bono. It's always feels a little fancy to me, but I'm an attorney at Public Law Center. I've been here about 13 years. I've spent my entire life until the last 2 years as a consumer attorney. So doing bankruptcy and foreclosure defense, debt collection defense, student loan issues, identity theft, kind of every different issue that might come up, plus some just additional civil litigation issues that have arisen in our practice. And then in the last couple of years, I've transitioned into being more of a management role. And my colleague Elizabeth was hoping to be here today, but she had a conflict. I joke with her all the time that I still try to pretend like I'm a consumer lawyer, and I'm very much involved in advocacy related to consumer work now, legislation and regulation and whatnot. So that's my background. It's definitely my passion, and I definitely, I'm definitely, worry about the clients and want to make sure that they have, the best possible representation and advocacy, whatever that may be for them. There's lots of bills that I'm working on to try to get more of those protections into the law. Not that that's relevant to today, but that's the kind of area, the way that I'm thinking about it now, just so you all know. Does that help? Is there anything else that I can share?
Oh, keep going. What was
Okay.
the name of the new California agency that you mentioned?
They call it, it's for short, the acronym is the DFPI, but it's the Department of Financial Protection and Innovation. It used to be the DBO, the Department of Business Oversight, and there was a bill last year that changed its name to the DFPI, as well as changed its focus a little bit more towards consumer protection and less towards business regulation, if that makes sense. Mm-hmm. So I'm trying, I don't know kind of what else makes sense necessarily for me to go into detail on.
Well,
could you talk to us about the role that you might consider for a paraprofessional in this area of practice?
Yeah.
Let me just say one thing, Lee, because I had a meeting with Elizabeth yesterday on wage garnishment, and I showed her what has been developed in terms of licensing of these paraprofessionals, which had not been developed the last time we talked about this topic. So thinking about Julia's question, think about it with respect to a group of folks who is either a JD, an LLM, or a certified paralegal, who has then met educational and experiential requirements and has passed a subject matter specific exam. So that's the new piece of information since last time you were with this subcommittee. And I just, sorry to interrupt, Julia. I just think it's important to get a sense of who these people are.
Yeah, good. Thanks.
Yeah, I can talk through that. I mean, I think, one of the things that, well, I'll tell you, like, for instance, in our practice, we use our paralegals substantially to help with a lot of tasks. I will say that the difference from my mind is that those tasks are always done under the supervision of a lawyer. And so that is still the piece that I think I struggle with a little bit. So just with that caveat, I really feel strongly that it makes sense to involve a lawyer with a lot of these things. But I'll tell you how we use our paralegals, for instance, and how I could imagine, a paralegal being used, which to me is not all that different from how a paraprofessional would be utilized, minus some of the I know that there's the legal advice difference, but so generally speaking, when our clients come in, if we've identified that it's hard to say like that there is a simple or a straightforward case, but that it's maybe the underlying debt is a credit card. We will have our paralegal prepare an answer, as well as, oh my gosh, I'm blanking on what the document is, but another document that we send off to demand information from the plaintiff, depending on what the causes of action are. So if they're raising particular common counts, then we will send off a demand for bill of particulars. That's the document, as well as the response, fee waivers, that kind of thing. Our paralegal prepares all of that. We have, we've created kind of guides and templates and samples that we use in our practice. Once that happens, we get hopefully it's, within the right time frame, the response to the bill of particulars. We'll review that. We'll go through discovery, both responsive discovery and propounding discovery. We have our paralegal assist with responding to discovery. We haven't had, I don't think we've had them propound discovery, although, well, our prior paralegal who'd been there for a few years, we did actually have her propound some discovery. And then we will have them help us with, we'll have them help us with the responses, but ultimately, we have our lawyers really kind of do the final review of that. And then identifying, the negotiations with the other side, going back and forth. If our clients are uncollectible, we often will be able to get these cases dismissed either because of our clients' income status and assets, or because there's a violation of a consent order or some issue under one of the other state laws that we're able to identify for the opposing counsel. And then that will result in a dismissal of the case.
Could you envision a paraprofessional engaging in those negotiations in lieu of an attorney?
I mean, so yes, I could see that, but again, like I will tell you, I mean, I'm really stuck on this idea of attorney supervision. So yes, I could totally see that, so long as there's that conversation about, I mean, focusing on those different, what the different violations could be, and ensuring that we're not, kind of disclosing the information we're not supposed to disclose, et cetera. So yeah, I could see the negotiations being handled by a paralegal or a paraprofessional, but I mean, I will say, just because that's been my experience, that I still would strongly encourage there to be attorney supervision.
Can you envision that there are any tasks that only an attorney does? For example, limited appearances in court that you could see a paraprofessional taking?
That's harder for me. it's hard to predict what's going to happen, with the court appearances.
So they're not relatively redundant, is what you're saying.
Part of the problem for me is the courtroom that handles these cases in Orange County handles them a little bit differently than in some other counties. And so ours are less redundant, I think, because of the way that this particular judge handles his courtroom. I don't necessarily, but so I can't really, and I've only practiced in Orange County. I've made appearances in LA bankruptcy court, but that's it. So I haven't practiced in other state courts. So I can't tell you, how they're handled in other areas. I suppose for the case management conference, that's, basically the trial setting conference where they're just, kind of setting dates. I could see that working. There's not honestly a lot of the other appearances are going to be arguing motions, pre-trial. If it's an unlimited civil case, then it would be, your mandatory settlement conference, et cetera. So those are not redundant by any means. I suppose the case management conference, it would be a possibility because that really is mostly setting dates. And so it's, mostly ensuring that the client knows when things are. But my issue is that, even as a lawyer, if the other side comes in with something, if the judge comes up with something, like, you just don't know necessarily. So it's hard for me to say that any particular appearance is going to be simple. Most of the time they are, but it's hard to plan for when they're not.
My experience with trial setting conferences is some judges want the actual trial attorney there.
Right. That's the other problem. Exactly. Because they need to know who's going to be, what the availability is and what dates they're going to be available for. So I would agree with you.
Steve, did you have another? Oh, okay. I have a couple questions. Lee, who are the attorneys for the plaintiffs in these cases? And do you see repeat
Yes.
people in that?
Yes. Yeah. There's not a huge number of them. There's a few, I would say, I don't know what the network is. I mean, I would say there's a few that kind of cover Southern California, a few different ones that cover Northern California, some that cover the whole state, but you definitely see repeat players.
Okay. What would you say is the level of ability of the attorneys who represent the creditors?
I'm being recorded, so
it may not be a fair question. Are they typically really skilled in these laws?
I would say, they know the areas that they need to know to file a large number of cases, right? So like these are bulk filed cases. They're filing 100, 150 cases at a time. It's less common, I think, for them to be, to have the detailed knowledge of the defenses that we raise, because that's not the area, they're not bringing cases based on those laws. They're bringing cases based on breach of contract and common counts. And so the issues that we raise in defense are more unique and not as, not part of their kind of regular day-to-day practice.
And by common count, there's a funny little thing in California law called a common count, right? It's right. A cause of action, not a.
They're like these funny little areas of common law but they are causes of action. And they're funny. They're terms like money lent and received, money had and received, or account stated, open book account. They're very kind of, and they if you look at the history of them, they go back to like the gold mining days. I mean, they're kind of really these old school kind of causes of action that don't really make a lot of sense, to be very honest with you. But yeah, so, and a lot of these cases are brought on some combination of those.
Okay. Now, just one more question, then I'll see if Steve and Julie, I don't want to keep all the time, but one of the things Leah mentioned, training and licensing and all that kind of thing, but one of the other areas that's really being discussed hotly and right now is getting started is ethics. And what will the ethics rules need to be changed to have these things happen? And in this area, I can envision rights of privacy, but also conflicts of interest and attorney-client privilege. So those are three big questions, but what are some of the issues with regard to making sure you've got rights of privacy of your clients protected?
No, that's a good question. We're dealing with this in some other areas, especially in terms of survivors. So many of our clients are survivors of violence, and we're trying to figure out, ensuring that their privacy is protected. I think very similar to, kind of confidentiality and privacy issues, we'd want to make sure that, that certain information is not disclosed in pleadings, even in negotiations. There's things that you need to be careful about sharing with the opposing party. Sometimes that involves medical conditions. Sometimes that involves, personally identifying information, as well as, what the other side is also identifying in terms of account numbers and all of that. I don't know how that would necessarily change the ethics rules, but along those lines of having to look at, how you might change the law. The other thing that comes up is that we actually had this situation happen where somebody was assisted by a non-attorney. Not sure that it was fully legal, that it wasn't the unauthorized practice of law, but it happened. And it didn't go well. And so we went to set aside a judgment, the judgment that was obtained as a result of this non-attorney's assistance, or ineffective assistance, essentially. And the judge wouldn't do it because they were assisted by a non-attorney, and they were trying to argue under a statute that required, the mistake or abuse and neglect of an attorney. And so I think the other thing that needs to be looked at is not just like the ethics in terms of, the rules of professional responsibility, but also the statutes that allow relief for the consumers or the debtors that are based solely on the acts of a lawyer. I think that would need to be reviewed as well to make sure that there's that relief or protection available.
That's what I was going to ask. I'm sorry to interrupt. Sorry about that. I was going to ask, what about the consumer, like as far as medical debt goes? Because you are specifically talking about representing the creditor versus the debtor?
So we only represent debtors.
Okay.
Yeah.
Okay.
So my question for you then, Lee, is there any task that you can envision that a paraprofessional who has their own office could perform that is maybe now done by a paralegal? So let's include kind of all the things that a paralegal would do with the supervision of attorney. In addition to those things, is there anything that you do as an attorney that you could see a paraprofessional doing in this kind of a practice if they were on their own and not in a law firm with attorneys?
That's a really hard question for me to answer.
Well, so what you're saying is off the top of your head, no.
Right. And I'll say, I fully understand that there's the licensing and the training and all of that. I understand that and I appreciate that. And I don't think that that's necessarily, and so it's honestly, part of it is it's hard to imagine because we don't have it. Right. And because we know that there's that, and from our perspective is, at least from my perspective, from my experience, when I've seen assistance by a non-attorney without attorney involvement, I've almost always seen bad outcomes. And I know that's because that's what I've seen, but that's just where my history is. And so it's hard for me to then, anyway, that's just where I'm coming from. So that, if that helps, that, that's what we see usually. Yeah.
Yeah, sorry, because I'm just on the phone. This is Joanna Petra. When you say you've seen bad outcomes when non-attorneys have been involved, I'm curious, like, who are you referring to when you say non-attorneys?
Well, I'm not sure, because we don't always know who the person behind the assistance is. But it's some individual who is assisting, either someone who becomes our client or someone who's, filing a lawsuit against one of our clients who's being assisted by a non-attorney. I don't necessarily know what their position is. I don't know if they are technically licensed as licensed under some part of California law, or if they're acting completely on their own. I just honestly don't know.
Okay.
Yeah.
Steve, you had Justice Petra, did you have a follow-up?
Lee, as I see it, there are sort of two animals. One is straight debt collection, which is most of what we've been talking about. The other is creditor harassment where the debtor may have affirmative claims. And we've heard from a lot of people that that category of litigation is done primarily in federal court under a variety of federal statutes. And that could arise one of two ways, either if the plaintiff chooses to file in federal court, or if they sue in state court under a federal statute, the defendant would have a right to remove to federal court. The only exception to that would be if you wait until the debtor is sued and assert that as a counterclaim, then the creditor would not be able to remove that to federal court. We've been advised by the State Bar's General Counsel that we're not going to be able to allow paraprofessionals to practice in federal court. And given that, I just don't see how we could allow them to operate in the creditor harassment arena. What are your thoughts on that?
Yeah, that was raised as part of my thought preparing for this meeting. There's a couple of things. I think that makes sense. I mean, I agree. Some of those cases can be brought in state court, particularly if you're only suing under Rosenthal and not the Federal Fair Debt Collections Practices Act. But it's hard to it's a very specific definition of what qualifies under Rosenthal versus what qualifies under the FDCPA, and I'm not sure that it'd be easy to kind of create regulations that differentiate between those two things. Maybe it is. I don't know. I guess that's what you guys get to look at. So I think it would be hard to consider, that affirmative creditor harassment cases because they are so often going to include one of the federal statutes, even if it's not Rosenthal, but not the Fair Debt Collections Practices Act, but the Fair Credit, Credit Reporting Act. A lot of times those two laws go hand in hand. So I do think that's challenging. The other thing I just want to mention, the other point under creditor harassment that was included was the cease and desist letters that get sent out to the creditors to stop them from communicating. And my only issue with that is those are widely available for free from, the Consumer Financial Protection Bureau, from the Sacramento Law Library. There's guides and templates that people can use in different languages, not just in English, but I think CFPB has them in a number of different languages. So I also would be, we help people with those, but a lot of times we have them, recreate them themselves because they're actually supposed to come from the debtor. And I would be, it would be a little bit silly, I think, to see somebody charging to develop those letters when they are, kind of on the internet and at local law libraries and whatnot for free. Would be my only other mention of creditor harassment there.
Thank you. That was very helpful.
Okay.
Lee, I think you have to hop off. Right, I saw Ryan's hand with the DA's office up. I think Hoon has joined us from the DA's office. I hope maybe Hoon or Ryan can help us with this, because I do feel like we get stuck and aren't able to fully understand how these cases proceed. Like what happens after this initial screening, you do some discovery, and then sort of what are the actual steps involved in the cases. We haven't quite gotten there. I did want to quickly ask you, Lee, just how often in your experience are these cases being filed in federal court? Because the federal court data that I pulled would suggest that statewide, there's just not that many cases being filed under any of these federal statutes. So like, is that your experience that like your office is frequently filing cases in federal court?
No, we don't. I mean, honestly, the FDCPA is something that private lawyers handle much more than legal services lawyers do. There's some legal services programs that do. Legal Aid Society of San Diego is one of them. They handle quite a few FDCPA cases. We haven't done as many. We've only filed a few recently. And oftentimes ours are in response to a cross complaint. And so, we are often in state court for the cross complaint because the client has already been sued for debt collection. And I do need to jump off because folks are waiting for me. But the last thing I'll say in terms of like the process, you do the screening, you do the response, you do motion work, you do the discovery, and then you have trial. I mean, that's really the way it works, especially in an unlimited civil case. It's usually on a shorter timeline. So, you know, you're not waiting years to go to trial. You're doing trial prep pretty much, you know, in your discovery, and then, you know, a few months later. So,
Lee, am I correct that in your straightforward debt collection case, the creditor is going to file a motion for summary judgment?
not in every case, but that does, some sort of dispositive motion does get filed at times, yes.
All right, and my experience is those rules are incredibly complex procedurally, and frankly, attorneys screw them up all the time. That's a polite way to put it. And
Oh,
there's
no,
a whole
never,
body of,
never.
there's
Never.
a whole body
Yes.
of case law about what to do when someone doesn't comply with separate statements and
Right.
and all of that. And my personal view is that is a morass, and non-lawyers should not be getting involved in that, but that's just my view. Care to comment?
As someone who's working on a response to a motion for summary judgment right now, I would also agree with you. The separate statements, you know, yeah, I think there's so many minefields in there that, like you said, I mean, lawyers, you know, it's not an easy thing for lawyers to jump into either. So I would agree with you. I think those are challenging. And I think, you know, it's definitely an area where I would, if there's a way to incorporate attorney supervision, it would be a very different story. You know, I think there's definitely a role for folks to play. I think it's great if there's an attorney supervising it, you know, to work with the person.
Unfortunately, our whole program is based on
I know.
non-attorney supervision.
But
So-
I'm gonna keep trying to sell it because I do
No,
think it makes.
you're preaching to the converted.
And you know, I know we'd use them, but anyway, I will jump off. Thank you so much. I'll come back if you guys have more questions, or send Elizabeth in if she's available in a future meeting. So thank you all.
Thanks, Lee. Ryan,
Okay.
thanks for your
Bye.
patience. And I see Hoon on. We can't hear you, Ryan. Can everybody else hear her?
No.
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 Now I see it. Now muted. There.
Unmute yourself, Ryan.
Are we talking about debt collection still, or should we?
Yes, we are, and we have another slide on creditor harassment. So I invited Ryan and Hoon with the LA County DA's Consumer Protection Unit. In response to, I think it was Amos asked to hear from, and I don't think he's here today, DA's office or in office that prosecutes these types of cases. And I had a great prep call with them, and I think they're poised to talk about this work and even the idea of paraprofessionals doing some debt collection representation. Ryan, maybe we'll just turn to Hoon because we can't hear you. You're muted. And you can't figure out how to unmute yourself, it looks like. Okay. So Hoon, Chun, welcome. Can we hear you?
Thank you.
Okay.
I assume you can hear me?
Yes.
Yeah?
Yeah.
Okay. All right, so as I understand it, you folks are thinking of having paraprofessionals enter into the realm of maybe helping people out with debt collection matters. So let me tell you a little bit about what our experience is with this issue area. So we're the Consumer Protection Division.
Oh, and Ryan, let me just interrupt you too. I didn't have a chance to meet with you and Leah. Could you tell us a little bit about your background as well?
I think that's what he's doing, Carolyn.
Oh, okay.
Oh, okay. And actually, I'm Hoon. But
Oh, I'm sorry.
anyways, no, it's all right. It's all right. It's just a little confusing. You're afraid of Ryan, that's all. I've been a prosecutor for about 27 years now. And half of that time, or actually most of that time, was doing traditional criminal prosecutions. But for the last 8 years, I've been a supervisor of the Consumer Protection Division, which is very different. Basically, we try to make businesses comply with the law We use a statute called Business Professions Code 17200, which allows us to seek penalties, injunction, and restitution where appropriate for any business that violates any law, whether it's federal, state, local, city ordinance, what have you. It doesn't really matter. Any violation of any law is considered an unlawful business practice. The penalties can be pretty substantial, up to maximum $2,500 per violation, and so that's. It sounds simple, but and it is. So as I've described it, it sounds simple, but because it's any violation of any law, it gets kind of complicated because obviously there's a ton of different laws, regulations, and so forth. One area that we have gotten into in the last, I would say, 3 or 4 years is debt collection. So, when I heard about this, I will be honest with the committee. I've had mixed reactions to this, and so let me tell you one of the things I do like about the idea. So what we've learned and we've dealt with very large, debt collectors, large credit card companies, some of the biggest around, and also these large, what they call outsourcing firms that basically are debt collectors. I mean, they're the call centers, right? And we were very surprised, shocked is probably a better word, when we entered into this area. And we saw that there were these businesses that were routinely calling people several hundred times in relatively short periods. I'm not misspeaking, several hundred times. And we were seeing, a lot of these investigations are confidential, and they're in the process, so to speak, and so I can't really talk about specific companies. But suffice to say, these are big companies, well-known companies. You'd certainly recognize them. And we're seeing, for some of these companies, for example, that they think it's okay to call somebody 8 times a day on their phone. I mean, just picture that. And you have to understand within this framework, they can't call before, I believe it's 7 a.m. or after 9 p.m. So you're talking about, what, a 14-hour window. And within a 14-hour window, getting 8 calls a day, every day, and they have and without limits on how many consecutive days, how long this can go on, quickly we add up to hundreds of calls. And, a lot of those lawsuits that you see are individual lawsuits by individual consumers. But what's missing from that picture is, because these things are rarely certified as a class action. I mean, every once in a while you'll see it, but very rare. These companies settle before it gets to that stage. But the Consumer Protection Division really doesn't, prosecutors don't really pursue any one particular victim's case here. So our division, we are concerned, and we do look at, I've often told the businesses we're looking at that we're kind of your worst nightmare, because we jump ahead and it's as though they're facing a class action that's been certified. And so we've gotten discovery, we've seen on a wide basis what these companies are doing. And we're seeing that it's not just anecdotal, it's not just the one person who happened to get called 5, 6, 7, 800 times is suing. These are routine practices. And we're talking about, we've seen hundreds of thousands of accounts of Californians where that's happening. So when I see that, it's obvious that even though there are very substantial deterrents to doing this. So for example, the Rosenthal Act has a statutory provision. It'd be great if it said a specific number. It doesn't, but it says you can't call with an unreasonable frequency. And I think most of us would would think that, yeah, calling several hundred times when the person doesn't give you any indication that they, they're not even picking up the phone, that would probably be unreasonable. And it's $500 per violation. So, you're talking about, depending on what threshold you set as unreasonable, anything above that, you could get you would get $500 per violation. So you would think with those kind of heavy penalties that these debt collectors would behave themselves, but they're not. So what's going on? The only way I can make sense of this is that there isn't enough pushback. The consumers don't know their rights. Consumers don't pursue their rights. They have difficulty getting legal representation, even at those kinds of numbers. And we haven't even gotten to like TCPA, you can't call somebody on their cell phone using a robo-dialer, and they all use robo-dialers, by the way. Although right now the Supreme Court's deciding what's the meaning of a robo-dialer, and that may or may not end as a protection for consumers. But so what has to be happening is that the companies are succeeding in essentially thumbing their nose at these laws. So, that part of it makes me, receptive to this idea of having a group of people that, that could potentially help consumers fight off these behaviors. Oh, by the way, I have to make clear that I'm speaking for just myself. I'm not speaking on behalf of the office, and I'm just trying to give you folks information. Okay. But then there's another side to this that does cause me concern. And it's that this is a very complicated area. There's an intersection of a lot of statutory schemes. There's the Federal Debt Collection Practices Act. There's the Rosenthal Act, which is the state version of that, but is by no means exactly the same. In many ways, it's more protective. You have the overlay of, the call recording statute, Penal Code Section 632, which we've also looked at, which is illegally recording somebody without their consent, okay? And then you have the TCPA, which I just mentioned, which right now is a very complicated area with split circuits on what the meaning of a robo-dialer is and so forth. And you have to be aware, and also in the background of any debt collection matter is bankruptcy law, which in itself, is a huge specialty. That it's often said they're bankruptcy lawyers and there's everybody else because this is an area. I mean, I've been practicing for 28 years, and I would not pretend to give advice to somebody on bankruptcy matters. How to file a bankruptcy petition, when does it make sense to file a bankruptcy petition, exactly what kinds of debts are forgiven in a bankruptcy petition. So there's a big overlay of many complex areas. So I would certainly urge caution, and if you're going to go into this area, and again, I don't offer an opinion about whether you want to do it, but if you're going to go into this area, proceed very slowly. This is not something you just want to throw out there and just see what happens. Let me give you just one real life example of this. So we were looking at a particular debt collector, and eventually, we ended up getting a pretty substantial civil penalty judgment against this debt collector. And one of the things that caught our attention was a private lawsuit that was brought by a lawyer, a trained lawyer, who knew what the value of a case was. So this is a debtor who owed maybe, just like a lot of debtors, maybe a few $1,000s in credit card debt, right? And then what happens is she keeps getting calls. She got 356 calls on her cell phone. And the funny thing was, it's not a cell phone that she ever gave. And to the collector, it was something they captured on a caller ID, but she didn't voluntarily give it. And so you'd have to know that that's not consent to be called on that number. You'd have to know about the TCPA, and you'd have to know that there's a mandatory minimum $500 per call penalty that's awarded to her for each call that can be tripled if the conduct is considered intentional. She got a judgment for $178,000. Okay, and this is just, again, anecdotal, admittedly, but just one small example of how if you don't have somebody who's really experienced and really knows this issue area, they can really screw over a debtor. So, anyways, that's my comments and thoughts. I'm happy to answer whatever questions you have.
Is it okay if I make a comment?
Sure.
Thank you, Mr. Hoon. I say thank you so much for pointing out that consumers don't really know what's available to them, right?
Right.
So we're up against many different maybe collections, but we don't know what's available, or we don't have the proper access, or we can't afford. So I just want to say thank you for pointing that out, because as a consumer, there's so many laws and things that I'm unaware of that I might be protected as a consumer. So I just want to say thank you.
You're welcome.
Okay. I have a question. It's kind of quiet here. As a trial attorney, evidence and evidentiary issues are top of mind for me. And so I asked our prior speaker, how do you think if a paraprofessional was going to work in this area, issues of attorney-client privilege, and then there's some others that are of concern as well. But just specifically, I think there's something called a mini Miranda somewhere. There's all kinds of things. How would you see that? Is there a way to solve that? If not.
I'm not sure I understand. My understanding of the mini Miranda in the context of a debt collection statute is a statement by the debt collector that says we're calling you on a debt for purpose of debt collection. Anything you say may be used against you in a proceeding. So, but I'm not sure I'm familiar with the attorney-client.
Well, a paraprofessional may or may not. We may have to change the law with regard to attorney-client privilege.
Right.
What would we have to do? Can you see a problem with regard to attorney-client privilege issues?
Oh, you mean
have a non-attorney?
that if a debtor speaks to a paraprofessional, they at least the way the law is currently written, that wouldn't be a privileged communication.
So this is Justice Petra. Let me just jump in for 1 second. So Carolyn, we're looking, this is an issue we're going to be addressing across all subject matter areas. And while Mr. Chun is certainly welcome to opine if he wishes to, I don't know that his area of specialization or knowledge would cover what exactly all the rules are around attorney-client confidentiality and what modifications would need to be made. But I certainly just want to assure you and everyone else that, of course, we'd be doing an overall look at what regulations, laws, statutes, rules need to be amended in order to appropriately implement any paraprofessional program that we recommend, and are certainly aware of privilege issues. So Mr. Chun, if you'd like to opine, you're certainly welcome to.
I think you're right. This is not an area. So as prosecutors, if we interview a victim of a bad practice or a criminal victim, whatever have you, those are not privileged. Even though we're lawyers, they're not our clients. We don't really, as I said, we don't really represent individual debtors, and so the issue doesn't arise. And so I don't know that I could be terribly helpful on that issue for your group.
Can I ask oh, sorry, Carolyn, go ahead.
Oh, we do have, and I forgot until Leigh mentioned it, there is a new California agency that's going to be talking about financial protection innovation. Mm-hmm. Is that something, do you know about them at all? Or what that's going to be? I do. I know that one of the issue areas that they're very interested in is debt collection.
And so, yeah, I mean, we're not really, they're sort of just getting started, but we definitely plan on coordinating with them and letting them know about some of the problems. I mean, one area, and this is not for this committee, one area I'd really like to see is I'd like to see some legislation passed that says this is how many calls maximum that you can make, you know, in a week, and then you got to stop after a certain period. I mean, the patterns that I'm seeing are really ridiculous. So
I'd like to ask a question.
sure.
Thank you very much for coming. Is there anything that you could provide us insight to that you could envision a paraprofessional doing along the lines of what it is that your practice entails? Can you imagine a role that they could specifically play as a non-attorney, but which would be of assistance to the consumer?
Well, so and I've given some thought to this. There are some things that would be enormously helpful, actually, that consumers can do that, and it really amounts to forms. So there's a letter that you can send, cease and desist letter, okay? And what we found is that every one of these companies respects the cease and desist letter, or they should. They're designed to, and then their systems break down and they screw up and they keep calling. But generally, at least the way their policy manuals are written, they have to you know, honor cease and desist letters. So that's something pretty simple that somebody can do. That would be helpful. Another letter that can be sent on behalf of a debtor is the prove-up letter. This really helps with one of the most abusive segments of the debt collection industry, which are the debt buyers. So have you folks learned anything about debt buyers yet? So I'll tell you a little bit if you're interested.
We have one on the line because we're going to hear in a moment from a private judgment collector, non-attorney.
Okay. So debt buyers generally buy debts at a steeply discounted rate. And generally speaking, they get spreadsheets. They don't get documentation. So what they get is a spreadsheet of debts, and it's, you know, degree of accuracy depends on who you're buying it from. You know, some of them are quite accurate, some of them are not, these spreadsheets. But you don't get the underlying documents, and generally the seller of this debt has written off the debt already, and they don't really want to bother with it anymore. And they're not really going to obligate themselves to help you collect this stuff. So one thing that really works, especially with the debt buyers, is a letter that says, prove up the debt. You know, I want proof of this debt. Generally speaking, I'm sure there are exceptions, but generally speaking, the debt buyer isn't going to have that because all they have is the spreadsheet. That's another letter. So things like that might be something that paraprofessionals could do, but with the understanding that they really should be referring or bringing on an attorney, I think. You know, if certain criteria are met, like, for example, someone's getting a lot of calls and so forth, so that an attorney can properly evaluate the other parts of it. So, but there are some things that I think paraprofessionals could do that might be very helpful.
That's what I was going to ask, Kuhn, because we know that I think some of the stats out there, like 99% of debtors in collections cases are not, these cases are proceeding by default, right? There's just, there's no access. So yes, in the best case scenario, everyone would have this amazing lawyer, but that's just not what's out there. And so I'm wondering, we talked in this group about the possibility of a screening tool that a paraprofessional would use to determine, like, can I take this case or not? And I think you and I maybe discussed that a little bit in our call, but I don't know what you think about the ability to create some kind of questionnaire that would then enable a filtering of cases, however imperfect, but just something.
Yeah, I mean, that's certainly a possibility. I mean, so if you're talking about default judgments, for example, there's some obvious markers. Is the debt going to be barred by the statute of limitations? Generally written debts, 4 years, for example. And also, so yeah, there are certain things that somebody could raise in basic debt collection actions that might be helpful. But you'd have to so in theory, I could see how you could create like a checklist like that. It would be a pretty complicated checklist, though, because of the many different areas, the many different potential counterclaims and issues. But yeah, I mean, in the abstract, I would say that that's certainly a possibility. But without actually seeing what that looks like and getting input from attorneys who practice in the debt collection field, it's hard to opine on that. I mean, in theory, it could work out well for everybody, right? Because perhaps this tool can, serve as a reference point of reference where lawyers who practice in this area can be alerted to really compelling cases. And so, if maybe everybody kind of works together on it, if it's possible, this could be a win-win for everybody.
Anybody else have any questions for whom or comments? All right, thank you both. Ryan, sorry we weren't able to hear your voice.
I don't know if you can
hear me now. Yes.
Can you
There
hear me
she
now?
is.
Yeah.
I just wanted to make sure that Stephen Fleischman's question for Leah about kind of the interaction between state and federal causes of action. I know that's something that Hoon has dealt with, and the fact that the paraprofessional would not be able to pursue a federal cause of action, that could and wouldn't necessarily even know about the federal statutes because it wasn't part of their area of practice. That could be a real detriment for someone conceivably because of the interplay and because of the limitations. So Stephen Fleischman had brought that up, and I know that Hoon has discussed that issue before. And so I just want to make sure he knew that had been a discussion topic in case he wanted to add anything to it. I have no opinion. I just am here as I was just listening.
Hoon, did you have any thoughts on that? How do federal law, you mentioned.
I'm sorry, are you talking to me?
Oh yeah, you
Hoon
mentioned
or Ryan?
Well, I'm a little lost at where we're going next, but just where do you think?
Carolyn's just asking you, Hoon, if you wanted to follow up on Ryan's.
Oh, yeah.
Yes.
I mean, yeah, of course. I mean, so there is a considerable amount of the practice that occurs in federal court. I don't know what you folks are thinking. I don't know if you're thinking of allowing paraprofessionals actually to make appearances in court. And I'm not sure if you've worked out all those details, but that is a fair issue, is that depending on what's filed there in state court, there could be removal to federal court, and that kind of creates a problem because while state legislatures can working with the judicial branch empower paraprofessionals to appear in state court cases, they're not going to be able to do that in federal court. And so if something gets removed to federal court, I don't know that there's a way that I mean, what happens at that point is the paraprofessional is going to have to drop out, and then, you know, and by the way, just so you know, I mean, from what I've seen, and again, we don't represent individual defendants, but we have seen in researching our companies, we look at these cases, and it is one of the most common things that I've seen is there's an action filed by a state court debtor, typically for some kind of abusive conduct, and it gets removed to federal court, either on federal question jurisdiction or on diversity grounds. So that is, you know, that is a potential concern here.
Okay. Thank you. Carolyn, I also see we have like a bounty of riches today after having no presenters for our last meeting. We have Judge Wise with Alameda Superior Court. If you'll recall, she had like 5 minutes at one of our meetings, and I'm so happy to see you here again, Judge Wise. I don't know how much of the conversation you've been able to hear.
Well, good morning, everyone. It's nice to be back here. I'm sorry it was short the last time. I actually jumped in between 2 hearings about 45 minutes ago, but the other link that I used, I wasn't on video and I could only see a presentation, and then they called me back to the bench. So I jumped back in here about 10 minutes or so ago, but I'm good for a little while. I have about 30 minutes that I could participate if there's some way I might be of use.
Okay. Steve, is your hand up?
Yes.
Like,
I'd like to ask Judge Weiss for her thoughts on something. Judge Weiss, in a nutshell, what our committee is looking at is allowing non-lawyers to practice law unsupervised by attorneys. So setting up shop on their own. And we have a great program developed that those people will have essentially be either certified paralegals or someone with a JD or LLM, but who for whatever reason has not taken it past the California bar. So I don't want you to think this is just licensing someone off the street to practice law. But having said that, we're talking about debt collection, and where my comfort level is maybe writing cease and desist letters, or maybe appearing at a settlement conference, or maybe even a trial setting conference. Where my comfort level ends is arguing substantive motions, particularly summary judgment motions, and then actual trial itself. That's where my comfort level ends. What are your thoughts on that?
Well, and I don't know if everybody in this call was on the last time I joined the last time around, and I don't want to waste anybody's time, but it might be helpful for you to just understand what I know and what I don't know, so that you can, you know, I understand the limits of what I can bring to the table here to be of assistance. So I have a fair amount of experience with these kinds of cases in fits and starts over a period of years. For a while, I inherited a calendar where, in addition to my normal settlement calendar that I was doing at that time, I happened to get the collection matters. So for a period of time, I had all of the limited collection matters, but it was relatively brief, maybe about a year. And currently, I don't see any limited collection matters, but I do see matters that have gone into default that are at a higher amount of money, or cases that have gone into default that are not collections cases at all. So that is the experience that I bring to it. I'm also aware of what I think everybody is probably aware that's coming, is that we have a set of unlawful detainer cases that are coming down the pike that I don't think directly impact this, but potentially you might be aware that while small claims is limited to $10,000, that there are all these new cases for people trying to collect rent, which are going to be a variation on collections cases, but they can exceed the $10,000 threshold. So for example, if somebody failed to pay rent during the entire time of COVID and their rent was $3,000 a month, there might be a claim, depending on how far out it is, for $40,000 or $50,000 of unpaid rent that can be brought for, the action brought, or potentially it becoming a collections type case for a much higher amount of money than it would have been before, within that paradigm. And I think you should just be aware of it, because I don't know if there'll be a sunset provision on that, and it could open up another class of cases you're not thinking about right now. Because one of the things that I thought about the last time I chatted with all of you was that where I see the greatest need and the greatest amount of challenge in terms of access to the courts, to people being put in a very difficult position who really are not equipped to be able to represent themselves, and who could really use the help, are the collection cases that are what I would say also fall into that category, which are below $10,000. Sometimes they're substantially below $10,000. It doesn't mean that they're in any way in a small claims action. In fact, for the most part, they're not, because the nature of the action is it's coming from a corporation. So they're filing them as a regular action in our regular civil departments. But I think I heard Leah mention, and this is certainly consistent with our experience, the vast majority of those cases go into default. Sometimes the service is dubious. Oftentimes the service looks like it's probably good based on the last information. Whether the person goes into default because they simply don't have the means to be able to do anything about it, or don't feel comfortable engaging the court on their own, or really they're at the point where they're throwing up their hands saying, this is just one more thing that I just can't deal with. So it's gonna shape up how it shapes up. Maybe 99% is too high, but it's I would say north of 90. There are definitely some people who come in and try to navigate the system on their own, who struggle. Some do it quite effectively, but that percentage is very, very small. I think that someone who could assist someone in navigating at least the early phases of that, a lot of those cases would go away. Historically, the way that we've approached it, at least in this county, is that if you've made it's often a debt collector or consolidator, but certainly not always, once they've brought the case, and once there is somebody who's responded on the other side, that we very quickly set it for essentially a settlement, an early settlement conference and trial setting. So you come in right then, and everybody's expected to bring everything that they have, your proof that you've paid the debt, the proof that you didn't incur the debt at all, or you don't have the right person. On the plaintiff side, the proof that the debt exists and they've got the numbers that are accurate. And historically, they would all come in person. We would send them to a room and they would go have a discussion. And in those cases, the vast majority of cases settled. The parties were able to work out some kind of an agreement. And interestingly enough, I would say it was about 50-50 on when we set those cases, the plaintiff didn't show up, as to when the defendant didn't show up in those matters, which is interesting, where really even the smallest amount of resistance or coming to court was enough to sort of have the plaintiff beg off of those particular.
Noelle,
Yeah.
this is Joanna. Let me just jump in for a second. I just want to echo that, because I have forgotten that reality. And then you just reminded me when I had these cases as well, that it was quite surprising to me, the frequency with which they just didn't show up.
Yeah. I think, that it's the extent that there's an approach where we want the lowest hanging fruit, right? The people who don't resist, or the people who aren't really responding at all. And then we'll maybe get judgments, and we'll try to collect on those judgments, and that its own sort of cottage industry around it. I don't know, maybe that would change if people had more access to somebody who is more of a paraprofessional who is coming in. And so the resistance maybe would trickle up a little bit. I really don't want to talk at you at all. I'm trying to be responsive sort of to what you said, but my general thoughts about this are that it's not a particularly effective system the way that it is right now, or at least not particularly effective when it comes to the defendants or the respondents in this matter. And I think there are things that we could do that would help to ensure people are treated in a more, more fairly, that they're treated more justly, that they have more access. A lot of these cases, I just don't think are the kinds of cases that most lawyers, even if people had the means, that most lawyers are going to want to take, because the debt amounts are, it's in many instances so small.
Judge Wise, thank you again for taking time. And
Sure.
just a real quick question. I know in California and courts where judges are trying more and more to get involved informally in discovery disputes and sorts of things like that. Is there a standing order that you may be able to point us to? That is very interesting that you mentioned an early settlement conference and having everyone bring their documents informally, sort of more like mini federal court. Is there something that you think that you have, or do you think that could be written for bench officers that might streamline that?
I wrote my order quite a long time ago, and so I can't promise that it's a literary work of art, but I would be happy to share what I have just for you to see it. I'm not sure how, we're all independent bench officers, even in our own county, so how many people have used the exact same thing, I don't know in the past, but I would be glad to share it with you. I can dig it up and forward it, the language that's used. I found that to be quite helpful, that process.
I'm gonna take my hand down.
Any other questions for Judge Weiss? Okay, thank you.
You're very welcome. Can I go ahead and jump off?
Yes. Thank you so
Okay.
much.
If there is another one of these in the future, you'd like me to come in or something specific, please don't hesitate. I'm happy to do it.
I guess I would ask you, because this issue comes up of like the cross complaints and affirmative claims that debtors have, and remedies under the Rosenthal Act and federal and state remedies for telephone call violations, and sort of a number of different avenues that a debtor could pursue. Is that something you frequently see?
Almost never. I mean, if I said it was where the defendant was trying to assert anything affirmatively, if that's every 1 in 500 cases or 1,000 cases, maybe it's not even that much.
Right.
And, other common things that are really troubling to me, and I would assume probably to all of you, I mean, the facts of, look, some of these cases are just run of the mill, completely reasonable. They're credit card, you took out a credit card, it's an interest rate that's, not ideal, but it's not ridiculous. It's maybe 8, 12, 16%, something like that. They pay for a while, then they stop paying, and the credit card company is trying to collect on that. I view that as different from this whole other class of cases that we see that are much more predatory, and they fall into lots of categories. They are sort of paycheck cashing kinds of things. They are short-term lender kind of options. They're people who need to get a vehicle, and the interest rate, I mean, even the price that they're paying for the car by all accounts is significantly over what the vehicle is worth. And the interest rates are usurious by any standard. I mean, I've seen interest rates in these cases run from 25% to 86%. I mean, they're just, the amount of abuse is really significant. And I don't know from county to county, when you're looking at courts that are as inundated with cases as we are, what the level of consistency is of judges really being able to spend the time and dig in to look at the underlying facts and see that, right? Actually dig deep enough into the documents to say, what do you mean 77% on a $10,000 loan for a 1989 Toyota Corolla? Like, what is that about? But those cases are out there, and they are far more common than one might think. And those cases are defaulting too.
Thanks. Welcome, Judge Yu.
Thank you. Sorry to be late.
It's nice to see you, Judge Yu.
Oh, good to see you too.
All right, well, I'll jump off then if no one wants or needs anything else from me, and perhaps I'll see you all again.
All right, thank you.
All right, take care, everyone. Bye-bye.
Thank you.
So Carolyn, I'd like to defer to you as chair. We have Richard Morrison, who's been very patiently waiting, and I really asked him to come to talk about enforcement of judgment work. And I think, Richard, if I'm correct, you specifically do not do credit card debt type of stuff. I don't think. I can't hear you.
I think it's good. I think it's good to hear from our speakers instead of making them wait.
Okay, and then we'll have the discussion. Okay, Richard, we can't hear you though.
He was right there.
No.
Or we could have a discussion.
We can't hear you.
I see.
This is our. He's not muted. No.
Maybe it's the rainforest that he's in.
Yeah.
It's a beautiful background.
Maybe you should log off and log back in. Okay.
Yeah.
All right.
I have to step away for about 120 seconds.
Okay.
2 minutes.
So maybe, yeah, I don't think Richard does exactly the consumer debt judgment enforcement. I asked him to join us as a way to pivot to the other topics under your purview, sort of enforcement of judgment generally. And I talked with Carolyn about how to proceed on the consumer debt question. We've heard a lot now from folks doing the consumer debt work. There is this distinction between, I think, defense in a debt collection matter and bringing an affirmative creditor harassment case. And certainly I've learned a lot more about that now. Let's see if Richard, you're on mute.
Taking myself off mute. Can you hear me now?
Yes, barely. Can you turn
well,
your
let me see
volume?
if I can get the microphone a little bit closer.
All right, there we go.
Sorry about that. So I think it's worthwhile pointing out to start with that post-judgment is debt collection, but it's a very different animal from pre-judgment debt collection. For example, we don't ever have to call a debtor to try to collect a debt. We can just move straight into levying a bank account or having the sheriff seize a car, or, whatever. But to give you a little bit of background here, I am the immediate past president of the California Association of Judgment Professionals. It was formed in the late 90s, mostly as a result of a rapid influx of judgment enforcers coming into the profession, resulting from sort of infomercial type ads, where judgment enforcement was touted as being a get rich quick scheme where you could work from home part-time in your jammies and make a bundle of money. And as a result, a lot of people were coming into the business who probably really didn't have any business being there. So some of the top judgment enforcers got together and formed this organization to raise the level of professionalism in the judgment enforcement community, because they were afraid of getting a black eye with the courts mostly. And so we present a one-day seminar for people who are coming into the business on how to do judgment enforcement ethically and properly. And we have an annual conference that includes topics like dealing with judgments that go into bankruptcy, alter egos, dealing with fraudulent transfers. I guess we're calling them avoidable transfers now, successor liability, community property issues, and how to levy real estate, how to skip trace missing debtors. And while most of us are non-attorneys, I'm certainly a non-attorney, some of them have been doing very well at this business, and I know a few that have retired very comfortably with what they've made enforcing judgments. But we have attorneys in our group. We have registered process servers, private investigators, and most of whom do judgment enforcement themselves. So the business model is taking a judgment on assignment. So the judgment is actually assigned to us, and we enforce them in pro per as our own judgment. And in conjunction with that assignment, there is a contract that allocates money that has been collected and how that gets divvied up. Usually this varies somewhere around 50%, sometimes more, sometimes less, which sounds like a lot, but there are huge risks in judgment enforcement. Judgments end up in bankruptcy court, or the debtor moves out of state. They go underground, they hide assets, transfer it to relatives, and so the whole process of figuring out what's a reasonable assignment to take, finding out whether the debtor is still around, then figuring out if they have any assets and where they're located, and then developing a strategy to collect those assets can be quite involved. So most of us non-attorneys who are taking assignments of judgments don't charge any upfront fees, which makes this a very attractive business model to people who may have smaller judgments in the 5,000 to 10,000 small claims range, and are underfunded to start with. And generally, we're not dealing with consumer debt judgments or unlawful detainers either, although some people do. And just sort of as a final word, I think this is really important work, because if someone who's been injured has no collection at the end of this long road, there hasn't been any justice. So I think what we're really doing is providing post-judgment access to justice. So with that, throw any questions you have at me.
Yeah, go ahead, Carolyn.
Okay, so there is this phrase that you hear every now and again called asset protection.
Yes.
And so what is your experience with that? And is that a good thing or a bad thing? Should paraprofessionals be allowed to help debtors with asset protection?
Well, if you have a very sophisticated debtor, and you're talking about a fairly large judgment, let's say a six-figure judgment, and they have had an asset protection attorney, it's tough going after that, but it can be done. The people who need low-cost help are not the ones who need asset protection. And unless you're moving funds offshore or developing a family limited partnership or something like that, that's not something that a paraprofessional probably ought to be doing. There are a couple of areas that I think are sorely needed as far as access to justice. Whether or not paraprofessionals would be doing that, I don't know. But certainly labor judgments are classically very difficult to enforce, especially for a non-attorney individual who's gotten a labor board judgment. And then there's a vast amount of child support that needs to be collected and isn't. And unfortunately, the tactics for finding where the stuff is, it just isn't taught in law school, as far as I can tell.
So I want to just prompt a little discussion. So this group has already decided that enforcement of small claims judgments would be included in the paraprofessional program. And Greg has raised the question of, well, why are we limiting it to small claims judgments? Why not sort of limited jurisdiction judgments as well? And I guess I want to ask Richard, in your experience, are there, what sort of generates the significant differences in the types of judgments that you're seeking to enforce? Is it the dollar amount of the judgment? Is it the type of the underlying debt? Just to sort of start to understand what might the rationale be for saying, well, the paraprofessional can enforce small claims judgments, but not any other judgments.
So are we talking about a paraprofessional taking assignment of a judgment or actually representing a creditor?
It would be representing a creditor.
Okay. Well, one thing to keep in mind, whether it's small claims or limited or unlimited civil, is that it can take a fair amount of work. I mean, most judgment professionals that I know of don't like to take anything under, say 5,000. Some will take smaller, but if you're splitting what you collect, there's not a lot of money there with a small judgment. And so if you're working on an hourly basis, representing a creditor who just doesn't know how to collect this money and what strategies are available, then it might work as a coach, but representing them seems like it's going to be fairly unpalatable to most of them when there's a very limited guarantee of success.
No, I know Greg is not totally available today, but
Well, no, I'm on the line.
Okay.
I'm on the line here. Yeah. So, I mean, I know at least with the regulation subcommittee, there has been talk about whether or not paraprofessionals would be permitted to charge contingency fees. And I think tentatively they have decided to recommend that they could, in certain circumstances, including family law judgments for enforcement of child support or enforcing labor commissioner judgments as well. So to the extent that they would, paraprofessionals might be charging an hourly fee, this may not be the best business model for this particular area of practice.
I absolutely agree with that. If they're allowed to work on a contingency basis, then this could work.
But I mean, I think they would run into the same problem that you identified with trying to enforce a small claims judgment, a small contingency fee on that. It may be very difficult for them to make that a manageable practice, as opposed to enforcing a judgment that was limited civil, resulted from a limited civil proceeding, or even an unlimited civil proceeding where they, for whatever reason, are not getting the assistance of an attorney. And I think what Leah was trying to, get at is there something that we are missing, and just based on your experience, that makes it inherently more complex for a paraprofessional to try to enforce a limited civil judgment as opposed to a small claims judgment or
I would say it probably doesn't have anything to do with the court that you're in, but it's the same set of strategies regardless.
yeah, that was my thought as well. I just wanted to get your perspective on that.
Okay.
Okay, thanks. Anybody else have questions for Richard? All right, it's a quiet group today. Thank you.
Yeah.
Thank you, Richard. Yeah, I don't know. It's quiet. Thank you, and thanks for hanging in there.
Okay, great. Thanks, guys.
Thank
Bye.
you.
Okay.
Bye.
Thank you so much. Yeah.
So Carolyn, as we discussed, I feel like it would be great if we could get some sense from the subcommittee as to where folks are on the consumer debt, at least starting with the defense, debt collection defense question, to try to move that one forward. I don't know. I talked to you a little bit about a straw poll. I know you don't like that concept, but I'm open, and or others on the subcommittee. Again, we've heard a lot about the debt collection work.
Can I make a comment about the child support collection? Can you guys hear me?
Well, and just towards Leah's point, I prefer to hear people's comments before, like a jury, we're sitting in the jury room. I would like to hear people kind of go around the table and give their comments on what they questions and answers, rather than just bang, take a poll right off the top of our head. I just don't think that's a good use of our time.
On the child support issue.
Yes, go ahead.
Yeah, I don't see that to be, there will be the rare and unique case where someone is hiding their resources in Ethereum or Bitcoin or whatever, and you have to go through Coinbase to track their wealth down, or they've moved their money to a non-Hague country. But for the most part, the Department of Child Support Services does a far superior job to what an attorney or a paralegal or a paraprofessional could do, because they can take your driver's license away, they can take your professional licenses away, they can take your passports away. I don't see that as an area where we need to license paraprofessionals to provide services. Thank you.
Can I ask a question, Stephen, about the Department of Child Support Services?
Yeah.
Are they involved in all child support cases? Because I did not think so, but maybe I'm mistaken.
They're not involved in all child support cases. They're involved if either the payor or the recipient wants them to be involved. They can be involved in terms of setting it. They're automatically involved if one of the parties is receiving public assistance.
Right.
Right. But
That's where I'm familiar with it.
Right. But anybody can get in the on the DCSS calendar or in the DCSS program and ask them. They have to be neutral. They're supposed to be there for the children. So
Sure.
Either parent can ask for it, whether they're paying or getting the support. So if someone's not going to DCSS for enforcement, then there's so much money at stake. The attorney involved going, it doesn't make sense to turn it over to DCSS, or there's that.
Well, there's also a lack of, and it's so interesting to me that you would raise that, because when I was had a family law department and my colleague was doing the DCSS calendar next door, I mean, I can just tell you, I had many cases, of course, typically self-represented individuals, where they were not receiving the ordered child support and were not getting help from DCSS or anyone else in trying to recover it.
Well, okay. So there have been situations where an individual, even though it's a state agency, each one's set up by county, there are DCS. I know personally, my wife had a 6-figure child support bill that was never collected. They let it go off the books. They determined to be, because they didn't want it to appear in the rolls anymore in the statistics for that particular DCSS department. So there are situations where DCSS is not actively pursuing, but in terms of frontline immediate payment of current orders, they've got far better resources than a private attorney does.
No, that's it. That's interesting. It's just I think there may be a lack of awareness as far as, or maybe I'm just in a county where they were not very available unless, you know, it was one of the recipients. So anyway, not to sidetrack the conversation, I was just curious.
Yeah, no, that's the thing. I will say, acknowledge it's county by county. And it could be very, and when it gets to a high enough amount, there is an incentive for a DCSS office to treat the debt as uncollectible, because then it doesn't count against their rolls. So the total uncollected child support is measured by county or by department, and ultimately is reviewed statistically to evaluate the performance of a particular DCSS subentity or agency or county. And so there is that incentive, if the arrears get big enough, for DCSS not to continue to pursue that. But generally speaking, in that situation, I don't know if DCSS can't collect on it, it's very unlikely that a private attorney or other private professional would be able to assist the recipient, from my observations.
May I ask a question? I'm sorry.
She's had her hand up for a while.
Okay.
But Nicole, please go ahead. I'm giving you my hand.
My question is, or just a thought based on the consumer with child support, what about the parent who has been responsible in paying, correct? They're being responsible in paying, and then there's an issue, maybe they lose a job, right? Now, they may be favored unreasonable because take their license, but they have a history of paying, but then there's some instances where there's a little bit injustice on part of those parents that are very responsible, and then they have some kind of life challenge that happens and they're not able to pay, and then they are treated worse than the individuals who don't pay at all. So there are those differences in cases that happen with those parents. Life changes or something that may happen, and there's a great impact, and then they are treated far worse if they've had an issue that they paid. They're very responsible, but then what do they do?
So the boundaries of what we suggested for family law paraprofessionals is going to cover that, because they're now going to have more resources to immediately file a motion to modify child support. Generally speaking, you're not able to modify child support retroactively. There is kind of an end run, like where the child comes and moves in with the other parent, the payor. They will deem that they have paid the support by actually paying for the actual support of the child who's living in their household. But I think that the initial issue there is they're not going in and modifying the support order because of that life circumstance, and we are going to be helping them by creating a new, hopefully more economical class of assistance for them through the paraprofessional program. In terms of the enforcement measures, again, when we come to the anecdotal stories, we could see much different stories from county to county in the state. I know in San Luis Obispo County, and I don't see it in Northern Santa Barbara County, if there is that truly life-changing event, the support officers who are attorneys, the ones that go to court, they're sensitive to that, and they're not hammering, the mother that just lost her job 3 months ago, or the father that had a disabling injury and is not yet getting a Social Security disability. So I don't see in that circumstance, but we are addressing it again by getting them more help to file the modification, because that's the most important thing to do in that situation. Does that help? Okay, thanks.
So Stephen, what you're saying then is that need is being addressed. So instead of really looking at it as a child support issue for us to look at here as a collections issue, I think you've, to my satisfaction, answered that question about that particular need. I know that the first speaker sounded like she didn't really.
Julia, I'm going to interrupt you because people have had their hands up for a while now.
Oh, I'm sorry, I didn't see.
Judge, you and then Steve. And I also want to say the child support thing, we may be going down a little, I know Richard brought it up, but I don't think that was the original sort of intention around the enforcement of judgment practice area. But Judge, you go ahead.
Thank you so much. Sorry, Julia, to cut you off.
Okay.
I've been thinking we've been doing this for a while, and I know Steve can tell us exactly how many meetings we've had and stuff, because he can track that so well, and I find that information from him helpful. I think discussion's great, but for me, I am putting in a plug for either, if you want to call it straw poll or whatever, because I think it's helpful for us to start to visualize what the resolution will look like, so we can start voting on it and peeling away what we want to include and what we don't. So I wanted to put in a plug for straw polling or whatever you want to call it.
Okay, thanks. Steve?
Yeah, I agree with Erica. We need to start taking some votes and including things or not including things. To me, the creditor harassment is an easy no. I just don't see any way around the federal question problem, the federal court problem. I think representing debtors in limited civil actions, I'm very, very skeptical about it, but I could be talked into it with reasonable limitations, like limited to limited jurisdiction court, limited to negotiating with the other side on settlements, having defaults set aside. I'm not comfortable with summary judgments or trials.
Okay, Julia?
So I'm comfortable with, even though the first speaker said she couldn't imagine charging for the cease and desist letter, I think that it's still a service that should be available, even if you have to provide some compensation for it, because in my experience, even though they're easy to find, the average person doesn't really know what they're talking about. They need some guidance and some information. And I think that's worth paying for someone to prepare it for them so that it meets the standard that's going to then in effect stop what is going on. So I'm for that. I'm interested in the other aspect of, you know, some sort of, what was the second document that he said in addition, the last speaker, it was a demand letter, I think, or a request for something?
Approve up.
Approve up. Those are the two things that I'm most interested in. And I think eventually I'd be very interested in hearing what the unlawful detainer folks would think about what Judge Wise talked about, because this sounds like a new area that's going to bring in a lot of need, but I don't know that we're ready to discuss that yet since the moratorium still exists.
I'm trying to pull up a Word document to take minutes. Try to put resolutions up. Judge, your hand's up again.
Yeah, thanks. I wanted to underscore what Julia said, because I think people don't know how to write their own cease and desist or demand type letters. And when they don't do it in a form that seems to be professional, they're not going to get the response. So it saves so much time and money if they just get that one letter and it looks like it's written by someone who's going to pursue it and knows what they're doing. So I just wanted to underscore what Julia said.
Steve, is your hand still up, or is that a?
Yes, it's up. I was going to say, I agree with Julia. I'm comfortable with those two letters, but really not much beyond that in terms of harassment of creditor harassment.
Okay, can you all see this screen? So this is very rough. And also, Carolyn, I think we have Ira in the attendees who would.
Yeah, if Ira has questions, yes.
Okay, Linda, can you promote him? So,
I wasn't asked, I don't have a question. I just wanted to give some information about the rent, the new form of small claims case for collection of rent. And some of you might know, but here's what it is. Starting about a year ago in March, tenants were allowed to not pay any rent, and then later pay 25% of rent, and be more or less immune, well, definitely immune from getting evicted for not paying the remainder. in other words, immune from March till August of last year if they didn't pay any rent, and immune from eviction from September through this coming May if they pay 25%. All right, so what happens to the unpaid rent? It can be collected by the landlord in the small claims court. And as you can see, the rent could be a lot higher than the small claims amount. Not hugely higher, I guess. That would be rare, but it could be a good deal higher. Okay, that's it.
Like Steve has another hand up again, and then I wanted to make a comment myself.
Yeah, Leah, add individuals before debtors on the first line.
Okay. Carolyn, did you?
Yeah. So as we make these resolutions, I think I made it pretty clear as I go along here that I find it very difficult to know with all these moving parts where to take a position. And we've had several meetings in the spring and the summer where XYZ was discussed and agreed on. And then we had committee meeting where things were reported. And then we had the legislation, the licensing, regulation, and disciplinary committee start to meet. But now we're here back again. And then again, now we've got a pilot program. And then again, on Friday, we're going to have a discussion of in court different ways, not in court. So I find it sort of difficult to be able to discuss this, having learned a lot this week about where the subcommittees who are still substantively discussing things are landing. And so I understand that we're going to have to come back again and look at this again, whether we agree with the two things we did or not did. So I'm really having trouble focusing on what we should do and not do.
So Carolyn, do you have a proposal for how we should be moving this forward differently from how we're doing it?
I think what we agreed to do in June was the way that we should be doing it, which was.
And keeping in mind that I was not part of this in June, tell me what you're referencing.
Yeah, what we agreed in June, and this was not, again, this happened really fast also, but what happened in June was we were going to discuss subject matter areas that would be included and excluded. Then we would talk about licensing, regulation, and discipline. Then we would come back and talk about implementation. Today, in January, February, and March, that's all of a sudden gone to a parallel 3-part roadmap that's almost impossible in some of these very complicated areas of law to discuss. We're layering on top of those 3 different tracks a discussion of court, in court, and not in court. So here we have something that we're talking about that is very much in court, not in court. You know, these might be smaller issues than the family law subcommittee is attending to. I wish I knew what they were talking about, but I don't have their report yet. I'm going to find it very hard to vote, even if my vote is a tie, any which way, because I don't understand what the general group is going to propose. There's a lot of question marks in my mind as to where we're going with this process for this little group and then the bigger group in full. Okay. But to answer your question, Your Honor, it was subject matter, licensing, et cetera, you know,
right. And then, you know, at the juncture that I looked at this not that long ago, we had this conversation at the working group, full working group level, certainly not, you know, the progress was not being made. And so with Leah's great guidance and Linda as well, there was an attempt to move things, actually move them forward. And I agree with you. There are a lot of overlapping areas. It can be very difficult. You know, we are not in a situation where we could all go have a retreat somewhere for 2 weeks and do, you know, nothing but this and talk about these things and get it done. I think it's unavoidable that there is going to have to be some back and forth. There's no way that you could determine the subject matters and exactly what's going to happen in those without having had any conversation regarding licensing, regulation, and the various things that are going on. So I hear you loud and clear. These are recommendations. You know, these subgroups are putting forth what you're thinking right now to the group to then be discussed as a whole. So it's not that, you know, this is going to be somehow set in stone at this point. I think that's impossible.
Yeah, just for your edification, Your Honor, my view is that we tackle the licensing, regulation, and discipline first, and then go and see what subject matter areas fit into the role that we would see this taking. So that might give you some flavor of where I came from.
Got it.
Carolyn.
Can I just, this is Greg, can I just jump in as well? I understand, Carolyn, that's your position. The problem is, especially on the regulation side and digging into the rules of professional conduct and the rules that would be needed, rules of court to frame out the program as well as potential legislation, is really difficult to complete that process without going through this process of understanding exactly what we're licensing them to do. So unfortunately, I think this has to be an iterative process. And as Justice Petru noted, I mean, these are recommendations from the subgroup that will go to the working group for discussion. Hopefully they will come up with a set of recommendations to the Board of Trustees, and then the Board of Trustees will consider that. There'll be a public comment period. And then the Board of Trustees will be making recommendations to the court and to the legislature. So there's many different parts to this process, and there's many different opportunities to step back and look at what we've decided and say, does this work? And I even think, actually, as part of the pilot program, we're going to be continuing to be in a bit of an iterative process to make sure that what we put down on paper actually works in a practical way.
Carolyn, this is Steve. We have 6 minutes left. We're not going to decide these issues today. My suggestion is we do the following. We ask staff to prepare a series of recommendations, whatever we call these, circulate them to all committee members, and have a 1-hour meeting with no witnesses, no testimony, and we just vote on these things. And we move it forward. I was hoping to get that done today. We didn't, but let's have these, staff seems to know where we're headed. So let's ask staff to put some together, but they must be provided to the committee a week in advance of whenever this meeting is. So we all have ample time to look at them. Then we can have a 1-hour meeting and start taking some votes. We don't need to hear from any more witnesses, is my view.
I agree with Steve, but I also want to chime in a little bit on what Carolyn was saying. Carolyn, being a part of the licensing committee and all the work that Stephen and I did, we got to the point where we couldn't work. We could not work in the substantive areas until the licensing framework was put into place about how prepared these individuals were going to be and what was going to be required of them to be able to participate. And until we had a sense in our minds of how proficient they were going to be, it was very difficult to start coming up with tasks to entrust them with.
And Julie, that's a good point, but it's that tasks that I think is somewhere the ball has to stop before you can meaningfully discuss all three areas. So when you say that, okay, the licensing we had to stop, well, then you stop and then you come back with that. I think what we're doing now is we're rolling through everything simultaneously. Greg used the word iterative. But I think at some point we decided the areas, then we wait and see what the licensing is. When we start to say court, in court, left, right, letter, not letter, it's not helpful until we know what you guys have done in your area. Be that as it may, I completely agree with Steve, and I think the way Steve fleshed it out is would be a good way to go. But go ahead, Julie. I don't mean to cut you off.
I just wanted to say we did put the licensing together and it got approved. Yeah. So save one issue we're going to be discussing soon. Licensing, until we get the subject matters completed, we're done. And it got approved by the whole group. So we did it.
Yeah, and if we could just use the 3 minutes, because I'm fine with what Steve has recommended, but there's a couple issues. One, we have several other topics under this subcommittee purview beyond debt collection and creditor harassment. One of them is the enforcement of judgment question. We've got wage garnishment, and we have utility shutoffs. So Carolyn, maybe you and I can talk offline, but there's other things we have to get through besides this set of issue too. I am worried about framing the resolutions for the consumer debt work in terms of what these folks are authorized to do versus what they are excluded versus the excluded activities. So when I send out these draft resolutions, just a heads up that I am going to send different versions, one that looks at excluded activities versus what's authorized, because I'm worried that we have heard from so many people, but we always sort of go into how complex these cases can be and various examples of that. We haven't really articulated all of the various activities. So I'm not sure we're in a position to have an exhaustive list of what should be included. Whereas on the exclusions, I think it's more clear. So I just wanted to raise that, get any initial reaction to either of those issues. One, we've got other topics to deal with. Two, I'm going to draft resolutions that look at what's excluded as well as the other approach of what's authorized. Any reactions to either?
And the other, that's fine, Leah. I will send you an email with my thoughts on exclusion and exclusions, and you and Carolyn can put those resolutions together as you see fit. In terms of the other two topics, candidly, for a pilot program rollout and given where we are, I'd rather just drop them. That's just my view, but I don't want to have more meetings and do more stuff to learn about wage garnishment again. We had someone talk about that at great length.
And I do have I met with her, and I do have a fully articulated kind of task list on wage garnishment. So we could look at that as a group. When the other two topics, you're talking about wage and utility, but there is also enforcement of judgment.
Enforcement of judgment, I think we'll be ready to vote on next time around.
With no additional speakers. Does everybody else feel that way?
We're talking about post-judgment enforcements like what Richard was just talking about. Yes, yeah. I'm comfortable voting on it next time.
Okay, all right. Sounds good. I understand what we're doing. Thanks for anyone who wants to send me emails in addition to Steve with thoughts on what should be in these resolutions. He's very welcome.
And I defer to the chairs, but if 1 hour seems insufficient and we want to make it 2 hours, that's fine.
Well, we already have another meeting scheduled, and it's already scheduled for 2 hours. So we will just, I think we can use that meeting for that purpose. It's April 8th.
All right.
Yeah. Okay. Thank you all.
See everyone tomorrow.
Bye.
Yeah, see you tomorrow.
Thank you.